Did you send a, if you will, final draft to?
Your Honor, unfortunately, I haven't been able to get my laptop to connect to the internet, but I have a USB that I can save it to, and then maybe print it out from there.
If you have a USB, you can give it to a thumb drive, right? You're talking?
Yes.
Yes, sir.
And I would assume you could give it to IJ to print out. Why don't you get her to print? And you've reviewed that, I
Yes, sir.
assume? Okay, so print that out. We'll go through it. Well, give it to Steve. All right, so as to this proposed or change, it's the defense, so go ahead.
Your Honor, thank you. The state is alleging several specific intent crimes. This is very unusual. Specific intent crimes are usually pretty obvious. I punch somebody, I hit somebody, I take a gunshot at them, try to run them over with a car, try to kill them. That's specific intent. State's allegations here are noticeably less clear and concise. Mr. McDonald intentionally filed documents wrong, and rather than documents were simply incorrect. The state cannot come in here and say, these documents were wrong, therefore Mr. McDonald's committed a crime. That's not the law. He's got to specifically intend to file false documents to get for his perjury, and the filing of false documents to exist. And that's one of the law that needs to be clarified very clearly to the jury. Now, this is particularly troubling to this officer of the court, and I've said in open, I've said several times, family court is one place where you absolutely don't have any choice. You can get drugged there by anybody, and if you run out of money, you're litigating by yourself. Now, if you don't understand how to do it, or if you're not a very sophisticated person.
You can make that argument. What I want to know is, and you provided me with the Supreme Court case, the issue is, should there be a explanation that, and I assume, I haven't seen or haven't gone through the entirety of the proposed jury instructions, but you want to amend this jury instruction to add the following, and I'll read it, so it's, I'll read the whole thing. Ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using as a defense his ignorance of the law. Thus, when the evidence shows that a person voluntarily did that which the law declares to be a crime, it is no defense that he or she, but he did not know that his act was unlawful or that he believed it to be lawful. Then you want to add, however, where the specific intent to commit a crime or willful conduct are required, ignorance of the law can prevent the required specific intent or willful conduct from being present. Correct. Correct?
Yes, sir.
Okay. So your argument that there are several specific intent crimes alleged, and you want to add that wording pursuant to Ratzel, I don't know how you pronounce that. Ratzelaff, United States, it's Supreme Court for the record, 114, Supreme Court 655. Anything else?
No, Your Honor, and this is unusual in that this is Mr. McDonald is doing obligations imposed by him at law. The vast majority of criminal cases are just prohibited from doing things. In this instance, the state is unsatisfied with the way he executed his duties by being hauled into family court, which I believe should give him a specific intent instruction.
Well, don't we have a specific intent instruction?
Or I should say ignorance of the law instruction.
Okay, is there a specific intent instruction?
Defining specific intent, no.
Yes. These are specific intent, or there are some specific intent counts, correct?
Yes, Your Honor.
And we need a definition of specific intent. All right, as to this instruction, go ahead.
Your Honor, I guess first I should ask, would a specific intent instruction kind of take care of the argument that we're arguing
Probably.
right now?
I don't know why there isn't one.
If that would remedy this argument, I think that's what we can agree to.
These, nobody disagrees these are specifics, there are several specific intent crimes, and yet, I granted you've been busy, all of that. Nobody put in a specific intent instruction. Crickets.
Again,
Okay.
I will make a record, Your Honor, this has already been said on the record, but our instructions were sent many days ago to yourself
Yes.
and to defense counsel. He made a record this morning that he was okay with every instruction except this one, even though he said that the standard instructions that are used in generally every case in the courthouse are accepted by him, except apparently this one, because it doesn't fit with his theory of the case.
Where is a specific intent instruction? My problem, and I'll let you address this addition. Well, first of all, if we put in a specific intent instruction, are you okay with that as opposed to this sentence, or is it one sentence? And second of all, I guess my question is, are required, it's not necessarily, you have your ignorance of the law can prevent the required specific intent or willful conduct from being present. Well, I suppose that, that's like saying if he, in any crime, if he didn't do it, then you can let him go. The case that you cited, which I have in front of me, says, and this is appropriate, you're correct. There has to be knowledge of the requirement, if you will, and this is under, and it seems to be very specific to the case. It's regarding the reporting requirement. Anytime a transaction with a bank is done for more than $10,000 or more. And so they go through a lot to discuss that the legislature put in the willful part. And therefore, and let me quote it, that he or she, but it was a he in this case, voluntarily and intentionally violated that known legal duty. Knew the structure in which he engaged was unlawful. And they go through and explain what this structuring is. In other words, and so it's clear, they talked about a case where somebody was making $9,500 deposits on a regular basis, and they said that that wasn't necessarily, well, it may have been structuring, but it wasn't willful. So they said a jury instruction, the jury had to find he knew the structuring in which he engaged was unlawful. The word willful, and again quoting from the case, word willful means no more than that the person charged with the duty knows that he is doing, knows what he is doing, not that he must suppose that he is breaking the law. That may have been, let me check, from there's an extensive, oh, that's what the minority said. So, Mr. Oh, man, I get, they're both M's. Mr. Mueller,
Yes.
if we put in an instruction from the standard instructions regarding willful, are you okay with that as opposed to this?
I certainly am open to that, Judge. I don't have it in front of me.
Does, look, I don't see where. I don't have, that I know of, a willful, does the state have one?
And Your Honor, if I could connect to the internet, I could find one very quickly.
I can't help you with that.
I know.
Was it in,
That's beyond your job.
was it in your original packet?
No, Your Honor, but we do have a standard jury instruction, I know. But I would need to connect to the internet to, but we could probably go grab one, get a
If you
paper
give me
copy.
about 5 minutes, I can go.
All
go
right,
now.
go grab one.
Okay.
Thanks, Frank. Yeah.
And you guys better tell them it's gonna take a half hour because we still gotta get them printed out.
I've already told them that the court had already started
Okay.
outside of their presence.
And so they said, and since I'm a firm believer with sticking with quotes from the cases, it said he does have to find, if it's willful, and the statute, and again, nobody has actually quoted the statute, but I assume the statute includes the language, the specific language, that the conduct has to be willful, because that's exactly what we're talking about in the Ratzlaff case. They were, I'll quote that statute, a person willfully violated this chapter, ... goes on to explain.
Counsel, your appearances for the record.
court has a few comments before we begin.
We are on the record in the matter, case D 505.
You guys either agree or I order.
You're going to convince me to hold your client in contempt.
Raise your right hand, face the court clerk to be sworn.
Any statement that you make is under penalty of perjury.
No, that's not how it works.
Okay, so Sandy gave you a final draft. We're not talking about this particular one, but just the ones that you agreed on. And did you have a chance to look to make sure there's no more mistakes?
Yes, Your Honor. At this point, there aren't any that I see.
Defense?
No, I don't see any mistakes, Judge.
Okay, so did you find what do you have?
I have a standard
Did you give it to
instruction. I had it emailed to your JDA as well, Your Honor. I showed it to defense. He doesn't have a problem with it.
Okay, so when you say, Mr. Mueller, what you don't have a problem, or he's saying you say you don't, does that mean that that is adequate as opposed to your red line here?
No, Your Honor, their instruction is a definition of specific intent. I agree with it, I'm open to it, I think it's a good idea that we add it. I do not, however, in any way, shape, or form removes a requirement or request that the addition of judicial language is added to the subsequent instruction.
All right, let me see the instruction. Okay. So this one, you're both agreeable to.
State's understanding is that would be in lieu of the addition to the other instruction.
I say, or suggest, if rather in lieu of, it should be in addition to. And if I would propose that the new specific intent definition instruction be added, it should be added directly in front of the one that we propose to have appended, and then they both go back to the jury.
All right, so here's the thing I have. However, with a specific intent to commit a crime or willful conduct are required, I would suggest we use the language out of the case, which says, for our adapting it to this, specifically what they said, which is
Which case are you referring to?
Rat's left. Do you want a copy of it? The U.S. Supreme Court case?
Right.
don't do what you did, which is say more or less, basically, this would be exactly what the opposite of what the minority says. They specifically pretty much, anyway, the point is, it says, have voluntarily and intentionally violated that known legal duty. And in Ratcliffe, they're talking about the duty to report. But that's,
Very specific to a niche argument, Your Honor. Kind of what you went through, that Supreme Court case involves bank standards, antitrust laws.
I get that, but it certainly applies here that he has to, because we have the same willfulness in there, that he have voluntarily and intentionally violated that known legal duty, or in this case, the known legal duty.
Correct. The last paragraph, Your Honor, I don't have a line because it's from my phone, but they say, in particular contexts, however, Congress may decree otherwise, meaning that in the first sentence, we do not dishonor the venerable principle that ignorance of the law generally is no defense to the criminal charge. In particular context, however, meaning this very specific niche argument and the context under Ratcliffe, which has some tenable similarities to our case, but nothing close to what is mentioned there.
Well, the statute itself, the statute we're talking about, are willful violations, virtually the same. Well, the willful, the legislature here in Nevada put willful, and what the Supreme Court is saying is that willful is not to be ignored.
That is correct, Your Honor. It just doesn't mean that a specific, in all specific intent crimes, that the person must have the specific intent to commit a crime and that ignorance of the law can be a defense. There's case law regarding burglary as a specific intent crime, and there's case law stating that a person can still commit burglary even if they don't realize that what they're doing are in fact felonies. So, and the state is being kind of blindsided because the state submitted its jury instructions to the defense about a week ago, and now shortly before closing, we're...
Believe me, I'm not thrilled. I asked both sides, and certainly you've had no opportunity to do any research on it.
I know you have the case in front of you, Your Honor, and you're aware that there's multiple very strongly worded dissents. I would point out the last paragraph of the last dissent. The majority's interpretation of the anti-structuring provision, that's a very specific provision that deals with that case, not ours, is at odds with the statutory text, the intent of Congress, and the fundamental principle that knowledge of illegality is not required for a criminal act. Now Congress must try again to fill a hole it rightly felt that it filled before. So again, they're saying this goes against everything in history, specifically for that case.
And your specific, or your both specific and general intent instruction come from a 2005 Nevada Supreme Court case. Bowman, are you familiar with that, Mr. Mueller?
Yes, generally, Judge, I try to read everything that comes out, but a lot of it doesn't stick, I'm not gonna lie.
I freely admit that in 2005 I wasn't doing criminal, so I didn't read it. But this, you're familiar with this, and you don't disagree, I guess, with this particular one,
Yes, Judge, I do not disagree that
which does
we
define
need
both
specific.
specific and general.
Yes, the context of this,
With the non-prohibit.
now,
Give me a minute, as I said, I like to be informed, I'm gonna read Bolton. You know, it's, well, I apologize, maybe I'm overly cautious because I've only been doing this a year, but I do read everything, so I can make my best effort to get it right. I'm sure that won't, I'm sure there will be different opinions someday from higher courts, but hopefully I got most of it. All right, anybody have anything else to add?
no, Your Honor, I think you've been very thorough.
No, Your Honor.
Tried. All right, I read Bolton, which is a Nevada Supreme Court case on the issue. And so it's clear, oh, here it is, okay. It's a 2005 case, so it's clearly almost 10 years after the U.S. Supreme Court case, and it discusses specific and general intent rather thoroughly. It's clearly the subject of that case, although they do mention Batson, surprisingly, but that was a different issue, of course. So I am going to give the definition. Specific intent is intent to accomplish a precise act, etc. And then general intent. I think that covers and defines what we have in this case. I certainly am not disagreeing with the U.S. Supreme Court in Ratzliff, but they clearly went out of their way to talk about the fact that that was a rather obscure, if you will, crime that in fact had to be explained, because they go into everything from the very beginning to explain that the defendant had to be told that had a way to get around the reporting limits of $10,000. And coincidentally, it's a Nevada case. But in any event, so the casino was telling this individual how to do it, etc. And the Supreme Court said how this, or the facts, were very specific to the case. This isn't, you can't shoot somebody. This is, you can't do a $10,000 transaction where you're taking cash and converting it, etc. And so I don't think, and even they say, and I'm talking the majority, that it doesn't change the fact that ignorance is no excuse. Ignorance of the law is no excuse. So I'm giving this, which we need to be put in without the cite. I'm giving the ignorance. I'm not adding that language. And so I will, although I don't have a clean copy, I will sign it and submit it. Does anybody have a clean copy of your proposal? I have some, I don't know if you, I know it's not mine, wrote the U.S. Supreme Court case on it. And there's a little known rule that I have to sign any jury instruction that I reject.
No, sir.
And I can tell nobody knows that, and it was told to me by Dan Polsenberg, and I looked it up, and he was absolutely correct.
Yeah, Your Honor, we were pretty pressed for time last night. We got hit with a lot of stuff we had been expected. There's no clean copy.
All right, then I'll sign this one, it'll be the court's exhibit.
I think, Your Honor, and for the record, you did very thorough, and I appreciate the court taking your time. I do object for the record. I believe
Absolutely.
I do believe this case is much closer to the Ratliff and the federal line cases, and that instruction should be given.
And this is a defense instruction.
Defense proposed, correct.
And it's from a course exhibit, it's actually 5.
What's that?
It's a 5.
Yeah. And do you, I assume, have that other, without the defendants proposed in here, in this packet?
That was emailed to the JEAs, your JEA, so she should be able to add it, because it was in the original packet.
Oh, here, it's here.
Oh,
It's in this packet. All right, so let's start off with the verdict form. We discussed that on the record, and the defense did object that they wanted clarification for each of the counts. I don't think that's necessary. In fact, I think it is, as I said, confusing. So I am going to give this verdict form. Now, instructions. Hopefully, you have copies, because I'm going to go through and read a small portion, and then it'll be numbered. Does everybody have a copy?
Yes, sir.
yes, sir.
Okay. And instructions to the jury is number 1. If in these instructions any rule is number 2.
Okay, got it.
And indictment is number 3, and that is several pages. Then the next, to constitute the crime charged, is number 4. And if I don't have it right or whatever, stop me right away, tell me. The defendant is presumed innocent is 5. You are here to determine is now 6. The evidence which you are to consider is 7. way, stop me when you think this specific intent should be inserted, or you can, if you want to take a second and discuss that amongst yourselves. The credibility or believability is 8. We're still not even into that type of a thing. Witness who has special knowledge, skill, number 9. It is the constitutional right of the defendant, is 10.
And Your Honor, the state thinks after that would be a good place for the specific intent instruction.
After that, we get into the actual crime charge.
Which is, defense.
Oh, I don't have an opinion, Judge.
Okay, then, is the start of the definitions for the crime, so that'll be 11. And this we need the one without the site. That's, well, it's 11 now, but it's the one on specific intent is the intent to accomplish. So, any person who by day or night is 12. You are instructed that forgery is 13. It is not necessary that the state prove is 14.
That's,
What's that?
never mind, Your Honor.
The intention with which entry was made is 15. Consent to enter is not a defense is 16. A person who enters an establishment is 17. Any person who in the commission is 18. Any person who falsely makes is 19. Any person who passes or attempts to pass is 20. Any person who with intent to injure is 21. Whenever an intent to defraud is 22. Any person who in a declaration is 23. Any person having taken a lawful oath is 24. The term oath shall include is 25. Any person who knowingly procures is 26. Then, for some reason, there's a sticker on this. A portion of the video, audio contained in State Exhibit 2 has been redacted as it contained. I think it should say contained, but doesn't matter. Irrelevant. Is there a reason somebody put an arrow exhibit to exhibit 2?
I think that was, Your Honor, because I handed a copy of, a paper copy of that instruction to your JEA. And then,
All I want to know is it correct?
I mean, it should actually say Exhibit 7 instead of Exhibit 2.
It's definitely not Exhibit 2.
Well, in reference to the video.
So, sorry, it's mostly correct, it's just.
All right, that needs to be corrected. So that will be,
Can we just strike out the number? And just The states and states exhibit has been redacted.
26. That will be 27. I think it should use it should have the exhibit number, if that's, is it, what exhibit?
I think actually, Your Honor, it might make more sense for it just to say
Contained in,
contained in some exhibits.
there's lots of exhibits
Yes,
that are
correct.
redacted. Is that what you're, the defense, Mr. Mueller, you're saying? And
Yes, sir.
so, portion of the video, audio, portion of some exhibits have been redacted.
Yes, Your Honor.
Portion of some exhibits have been redacted as it contained, all right, municipal evidence, you are not to infer anything from said redaction or consider it in your deliberations. Okay, that will be 27 with these changes. Ignorance of the law is no excuse is 28. Although you are to consider only the evidence is 29. In your deliberations, you may not discuss is 30. During the course of the trial is 31. When you retire is 32. Okay, so this is readbacks if during your deliberations is 33. And now you will listen is 34.
Where's the sentence instruction? Okay, got it.
Is it there?
Is there?
It's there.
Okay, you're right, it needs to be. What one is it now that they're numbered? So-
29.
Okay. Okay, so, wait a second, so there are at least two that need to be corrected, you have those, and then these are the numbers.
Okay, I don't think this is even in here on the last version.
No, it's not, but I numbered it, so.
Okay, so I have to type it, so it's not.
Yes, you have to type it without the site,
Got it,
and then I'll have to put the number on it.
right. Got it. Need to clarify this.
Okay, yeah, in the verdict form, usually we don't put in AKAs, but let me ask, is the defendant's name Michael L. McDonald?
Yes, sir.
I know that, like, in the last one, it was wrong. They put the wrong thing, but anyway, then we say we, the jury, and the above, et cetera, AKA Michael Lee McDonald. We don't usually leave AKAs in the verdict form.
No, we shouldn't.
I apologize, Your
All
Honor.
right, can you, so we don't have to read, so Sandy doesn't have to type it, because that's the only other way. Can you make that change?
Yes,
It's in the body of it, it's not up at the
yeah,
top.
I see it.
Okay.
All right.
And then these are the word forms, so I'll just pull it out.
So that's going to take, once she makes those corrections, it's still going to take 15 minutes to make all the copies, so you need to, before she does it, I'm going to have her, you, whatever, both stand at the podium and go through make sure it's the final draft before we make 20 copies.
you have just one verdict form, or do you have two?
Just one.
Just the one, okay.
Just one.
There was no two
Defendant.
proposed?
No.
Okay.
Defendant was okay except for the objections that they wanted then. That's all on the record.
Okay.
And to be clear, everyone's fine with Michael L. McDonald for just taking out the AKAs.
Yes, that's my understanding.
And just make sure it doesn't say Michael Lee in between anywhere.
We actually, there was two different first names on one, and nobody knows. That particular, the specific intent, it says it is not necessary for the prosecution to prove that the defendant intended precise harm or the precise result which eventuated if the crime is a general intent crime. Is that how it reads? Or is that a...
I believe that's a direct quote from the case, Your Honor. I mean, I think it may be dealing with more.
I have bold, no, but eventuated in a crime, which eventuated in a crime, not if a crime. Oh, oh. All right, I'll hold it, I have to we try to avoid really sounding.
If a crime is a general intent, I mean, arguably. Yeah. Yeah, it's which eventuated if a crime is a general intent crime.
It is not necessary for the prosecution to prove that the defendant intended the precise harm to become or the precise result which eventuated. If somebody knows where it is, so I can note it correctly.
Where in Bolton it is?
Yeah. I mean, it just sounds so, legalese, we're trying to define this as opposed to, I hate to say it, but well, if you guys are both okay with that, then I'm fine.
It's a standard instruction, Your Honor.
I get that, but that doesn't mean, we're supposed to be simply explaining this, and that is always a problem.
I understand, Your Honor. Just I think it's the result of us needing to.
Defense, are you okay with the wording of that?
My colleague represents an officer of the court that's out of the instruction book.
Well, here it is, I found it. state, and, I'll read it to you. It is not necessary for the prosecution to prove that the defendant intended the precise harm or the precise result which eventuated. I don't know, it just doesn't sound grammatically, it's like, whatever. All right, so here is the instruction for you to look at. And this will be, what number was this going to be? 11.
Yes, sir.
11, so I will, all right, here, look at this, make sure it's right. Oh wait, I'll give you the whole thing. Did she give you the whole thing? All right, hang on.
She just gave me the verdict forms.
Okay, so I have the final, but the one where we said a portion of some exhibits, what number, does anybody know what number that was supposed to be?
I think we were just going to say exhibits without specifying.
27.
Oh, you mean the number of these, I'm sorry.
27.
You sure before I mark it?
Yes, Your Honor.
All right, so I'm going to hand you this, and both of you look at it, go through it, and then we'll make 16 copies. And get this shown around. You want to take it, look, both of you look at, go through each one, so, because we've had mistakes done in the past where something gets.
Let's just go through here.
Either way, wherever you want. Go through it together, and that's going to be it before we use a whole tree or two.
All right, thank you for the review, problem.
Those two that we revised, 11 and then a portion of the exhibits.
They don't, we're going to make copies. They're going through all of it together.
So then we'll make 18 copies. Your Honor, I believe defense counsel and the state are both satisfied with this
All
copy
right,
of the
16 copies. Give it to Kathy.
We'll do 18 so they have their full.
What? 18, 14.
15, 16, 17.
You guys need The original and blue pencil. All right, bring them in.
Please rise for the jury.
Please be seated. Good afternoon, ladies and gentlemen. Parties acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Ladies and gentlemen of the jury, as you can see, we have a copy of the jury instructions for each of you. You can, if you wish, follow along as I read them, but you will be able to bring those back with you in deliberations to discuss. You will also have a single verdict form. If I don't give everybody a copy because it can lead to problems with which one's the real one and etc. So you'll have one verdict form. If you spill coffee on it, if you make a mistake, don't worry. Just tell the marshal and we will substitute a clean, fresh copy and you can continue. It happens, people start writing and you may write on something else. Don't worry about it. I just don't want more than one copy there so there's no confusion. It is now my duty as judge to instruct you on the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. If in these instructions any rule, direction, or idea is repeated or stated in a different way, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others. But you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. An indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged in an indictment that on or between the 4th day of December 2017 and the 21st day of March 2018, the defendant committed the offenses of burglary, Category B felony, NRS 205.060, NOC 504.24, forgery, Category D felony, NRS 205.090, 205.095, 205.110, NOC 50462. Perjury, category D, felony, NRS 199.120, NOC 52971. Perjury, category D, felony, NRS 199.145, NOC 52975, and offering false instrument for filing or record, category C, felony, NRS 239.330, NOC 52399. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of one or more of the offenses charged. Count 1, burglary. Did on or about December 4th, 2017, willfully, unlawfully, and feloniously enter with intent to commit a felony, to wit, forgery, and or offering false instrument for filing or record, the District Court Clerk's Office located at 200 Lewis Avenue, room 3317, Las Vegas, Clark County, Nevada. Count 2, forgery. Did on or between December 4th, 2017, then and there willfully, unlawfully, and knowingly, and feloniously with intent to injure or defraud, make, alter, or counterfeit a certain writing or instrument, or knowing the same to be forged, altered, or counterfeited, did utter, dispose of, or put off as true and genuine, or make any false entry in any public record or account, or have in his possession with the intent to so utter, offer, or dispose of, or put off said forged writing or instrument, to wit, a letter dated August 31st, 2017, written and signed by Nancy Sargent Hunterton, M.A., L.M., F.T., addressed to the Honorable Linda Marquis, Department B, 8th Judicial District Court, Family Courthouse, 601 North Pecos Road, Las Vegas, Nevada, 89155. R.E. Michael McDonald, date of birth October 22nd, 1983. Case number D15518905D. Thereafter, defendant did utter or publish the same or any copy or purported copy thereof as true by filing the said letter at the District Court Clerk's Office, 200 East Lewis Avenue, room 3317, Las Vegas, Nevada, as Exhibit 1 to defendant's motion to recuse or dismiss Judge Linda Marquis or other relief in case number D15518-905D. Count 3, offering false instrument for filing or record. Did on or about December 4th, 2017, willfully, unlawfully, knowingly, and feloniously procure or offer a false or forged instrument to be filed, registered, or recorded at the District Court Clerk's Office of the 8th Judicial District Court, 200 East Lewis Avenue, room 3317, Las Vegas, Nevada, to wit, a letter dated August 31st, 2017, written and signed by Nancy Sargent Hunterton, M.A., L.M., F.T., addressed to the Honorable Linda Marquis, Department B, 8th Judicial District Court, Family Courthouse, 601 North Pecos Road, Las Vegas, Nevada, 89155. R.E. Michael McDonald, date of birth October 22nd, 1993. Case number D155-18905D, filed as Exhibit 1 to defendant's motion to recuse or dismiss Judge Linda Marquis or other relief in case number D15518-905D. Said instrument, if genuine, might be filed, registered, or recorded in a public office under any law of the state of Nevada or of the United States. Count 4, burglary. Did on or about March 13th, 2018, willfully, unlawfully, and feloniously enter with intent to commit a felony, to wit, forgery and/or offering false instrument or filing or record that certain building occupied by Clark County Family Courts and Service Center located at 601 North Pecos Road, Las Vegas, Clark County, Nevada. Count 5, forgery. Did on or about March 13th, 2018, willfully, unlawfully, knowingly and feloniously, with intent to injure or defraud, make, alter, or counterfeit a certain writing or instrument, or knowing the same to be forged, altered, or counterfeited, did utter, dispose of, or put off as true and genuine, or make any false entry in any public record or account, or have in his possession with the intent to so utter, offer, or dispose of, or put off said forged writing or instrument to wit, a letter dated August 31st, 2017, written and signed by Nancy Sergeant Hunterton, MA, addressed to the Honorable Linda Marquis, Department B, 8th Judicial District Court, Family Courthouse, 601 North Pecos Road, Las Vegas, Nevada, 89155. R.E. Michael McDonald, date of birth, October 22nd, 1983, case number D15518905D. Thereafter, defendant did utter or publish the same or any copy or purported copy thereof as true by filing the said letter at the District Court Clerk's Office, Clark County Family Courts and Services Center, 601 North Pecos, Las Vegas, Nevada, as Exhibit C to defendant's exhibit list to a March 16, 2018 evidentiary hearing in case number D15518-905D. Count 6, perjury. Did on or about March 13, 2018, willfully, unlawfully, feloniously, and knowingly make a false statement in a declaration, affidavit, oath, or other instrument under penalty of perjury in the following manner, to wit, by submitting to the 8th Judicial District Court in case number D15518905D, an affidavit signed by the defendant titled General Financial Disclosure Form, in which defendant falsely stated that he was unemployed and/or falsely stated his income. Count 7, offering false instrument for filing a record. Did on or about March 13, 2018, willfully, unlawfully, knowingly, and feloniously procure or offer a false or forged instrument to be filed, registered, or recorded at the District Court Clerk's Office for the 8th Judicial District Court, 601 North Pecos Road, Las Vegas, to wit, a letter dated August 31st, 2017, written and signed by Nancy Sergeant Hunterton, MA, LMFT, addressed to the Honorable Linda Marquis, Department B, 8th Judicial District Court, Family Courthouse, 601 North Pecos Road, Las Vegas, Nevada, 89155, R.E. Michael McDonald, date of birth October 22nd, 1983, case number D15518905D, filed as Exhibit C to defendant's exhibit list to a March 16, 2018 evidentiary hearing and/or a general financial disclosure form containing false information regarding defendant's employment status and income Said instrument, if genuine, might be filed, registered, or recorded in a public office under any law of the state of Nevada or of the United States. Count 8, perjury, did on or about March 16, 2018, willfully and lawfully, feloniously, and knowingly, after taking a lawful oath in a judicial proceeding, swear or affirm willfully and falsely in a matter material to the issue or point in question, to wit, by providing false sworn testimony in case number D15518-905D as the defendant's employment status and income. Count 9, burglary, did on or about March 21st, 2018, willfully and lawfully and feloniously enter with intent to commit a felony, to wit, forgery and or offering false instrument for filing or record that certain building occupied by Clark County Family Courts and Service Center located at 601 North Pecos Road, Las Vegas, Clark County, Nevada. Count 10, forgery, did on or about March 21st, 2018, willfully, unlawfully, knowingly, and feloniously, with intent to injure or defraud, make, alter, or counterfeit a certain writing or instrument, or knowing the same to be forged, altered, or counterfeited, did utter, dispose of, or put off as true and genuine, or make any false entry in any public record or account, or have in his possession with the intent to so utter, offer, or dispose of, or put off said forged writing or instrument, to it a letter dated August 31st, 2017, written and signed by Nancy Sergeant Hunterton, MA, LMFT, addressed to the Honorable Linda Marquis, Department B, 8th Judicial District Court, Family Courthouse, 601 North Pecos Road, Las Vegas, Nevada, 89155. R.E. Michael McDonald, date of birth, October 22nd, 1983, case number D155-18905D. Thereafter, defendant did utter or publish the same or any copy or purported copy thereof as true by filing the said letter as or at the District Court Clerk's Office, Clark County Family Courts and Services Center, 601 North Pecos, Las Vegas, Nevada, as Exhibit 1 to defendant's motion to recuse and or dismiss Judge Linda Marquis, an assignment of an unbiased impartial judge, motion for unbiased retain and or retrain and or reconsideration by impartial judges and other relief in case number D15518-905D. Count 11, offering false instrument for filing or record, did on or about March 21st, 2018, date willfully, unlawfully, knowingly, and feloniously procure or offer a false or forged instrument to be filed, registered, or recorded at the District Court Clerk's Office for the 8th Judicial District Court, 601 North Pecos Road, Las Vegas, Nevada, to it a letter dated August 31st, 2017, written and signed by Nancy Sergeant Hunterton, MA, LMFT, addressed to the Honorable Linda Marquis, Department B, 8th Judicial District Court, Family Courthouse, 601 North Pecos Road, Las Vegas, Nevada, 89155. R.E. Michael McDonald, date of birth, October 22nd, 1983, case number D155-18905D. Filed as Exhibit 1 to defendant's motion to recuse and or dismiss Judge Linda Marquis, an assignment of an unbiased impartial judge, motion for unbiased retrain and or reconsideration by impartial judges, and other relief in case number D15518-905D. Said instrument, if genuine, might be filed, registered, or recorded in a public office under any law of the state of Nevada or the United States. Each charge and the evidence pertaining to it should be considered separately. The fact that you may find the defendant guilty or not guilty as to one of the offenses charged should not control your verdict as to any other offense charged. To constitute the crime charged, there must exist a union or joint operation of an act forbidden by the law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant is entitled to a verdict of not guilty. You are here to determine the guilt or innocence of the defendant from the evidence in the case. You are not called upon to return a verdict as to the guilt or innocence of any other person. So if the evidence in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proof. You must not speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence. It may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strengths or weaknesses of his or her recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his or her testimony which is not proved by other evidence. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his or her opinion as to any matter in which he or she is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if, in your judgment, the reasons given for it are unsound. It is a constitutional right of a defendant in a criminal trial that the defendant may not be compelled to testify. Thus, the decision as to whether the defendant should testify is left to the defendant on the advice and counsel of the defendant's attorney. You must not draw any inference of guilt from the fact that the defendant did not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Specific intent is the intent to accomplish the precise act which the law prohibits. General intent is the intent to do that which the law prohibits. It is not necessary for the prosecution to prove that the defendant intended the precise harm or the precise result which eventuated if a crime is a general intent crime. Any person who by day or night enters any room or building with the intent to commit any felony is guilty of burglary. You are instructed that forgery and offering false instrument for filing or record are felonies in the state of Nevada. It is not necessary that the state prove the defendant actually committed a felony inside the building or room after the defendant entered in order for you to find the defendant guilty of burglary. The essence of the crime of burglary is the entry with criminal intent. Therefore, a burglary was committed if the defendant entered the building with the intent to commit a felony, regardless of whether or not that crime occurred. The intention with which entry was made is a question of fact which may be inferred from the defendant's conduct and all other circumstances disclosed by the evidence. Consent to enter is not a defense to the crime of burglary, so long as it is shown that entry was made with the specific intent to commit a felony therein. A person who enters an establishment with the intent to commit a felony therein is guilty of burglary, even though the entry was made through the public entrance during business hours. The authority to enter a building open to the public extends only to those who enter with a purpose consistent with the reason the building is open. The fact thereof that the establishment is open to the general public is not a defense to the charge of burglary, so long as the defendant is shown to have made the entry with the intent to commit a felony therein. Force or breaking as such is not an element of the crime. Any person who in the commission of a burglary commits any other crime may be prosecuted for each crime separately. Any person who falsely makes, alters, forges, or counterfeits any record or any document or paper recorded or filed in any court with the intent to damage or defraud any person or persons is guilty of forgery. Any person who passes or attempts to pass as true and genuine any false, altered, or forged record or any document or paper recorded or filed in any court knowing the same to be altered, forged, or counterfeited with the intent to prejudice, damage, or defraud any person is guilty of forgery. Any person who with intent to injure or defraud makes any false entry in any public record or account is guilty of forgery. Whenever an intent to defraud constitutes a part of a crime, it is not necessary to aver or prove an intent to defraud any particular person. Any person who in a declaration made under penalty of perjury makes a willful and false statement in a matter material to the issue or point in question is guilty of perjury. Any person having taken a lawful oath or made affirmation in a judicial proceeding or in any other matter whereby law, an oath or affirmation is required and no other penalty is prescribed, who swears or affirms willfully and falsely in a matter material to the issue or point in question is guilty of perjury. The term oath shall include an affirmation and every other mode authorized by law of attesting the truth of that which is stated. A person who shall state any matter under oath shall be deemed to swear thereto. Any person who knowingly procures or offers any false or forged instrument to be filed, registered, or recorded in any public office, which instrument, if genuine, might be filed, registered, or recorded in a public office under any law of this state or of the United States, is guilty of offering false statement for filing or record. A portion of some exhibits have been redacted as they contained irrelevant and or inadmissible evidence. You are not to infer anything from said redaction or consider it in your deliberation. Ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using as a defense his or her ignorance of the law. Thus, when the evidence shows that a person voluntarily did that which the law declares to be a crime, it is no defense that he or she did not know that his or her act was unlawful or that he or she believed it to be lawful. Although you were to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. In your deliberations, you may not discuss or consider the subject of punishment, as that is a matter which lies solely with the court. Your duty is confined to the determination of the guilt or innocence of the defendant. During the course of this trial and in your deliberations, you are not to, 1, communicate with anyone in any way regarding the case or its merits, either by phone, text, internet, or other means. 2, read, watch, or listen to any news or media accounts or commentary about the case. 3, do any research such as consulting dictionaries, using the internet, or using reference materials. 4, make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. You may, of course, during your deliberations, communicate with other members of the jury while you're in the jury deliberation room, after the case has been submitted to you for deliberation. When you retire to consider your verdict, you must select one of your number to act as foreperson who will preside over your deliberations and will be your spokesperson here in court. During your deliberations, you will have all the exhibits which were admitted into evidence, these written instructions and forms of verdict, which have been prepared for your convenience. Your verdict must be unanimous. As soon as you have agreed upon a verdict, have it signed and dated by your foreperson, and then return with it to this room. If during your deliberations you should desire to be further informed on any point of law or hear again portions of the testimony, you must reduce your request to writing signed by the foreperson. The officer will then return you to the court where the information sought will be given to you in the presence of and or after notice to the district attorney and the defendant and the defendant's counsel. Playbacks of testimony are time-consuming and are not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so that the court recorder can arrange his or her notes. Remember, the court is not at liberty to supplement the evidence. Now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence as you understand it and remember it to be, and by the law as given to you in these instructions, with the sole, fixed, and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. State.
Thank you, Your Honor. Ladies and gentlemen, the evidence shows that on September 27, 2017, the defendant, Michael McDonald, filed in family court a copy of a letter that his therapist, Nancy Hunterton, wrote for him. And had he stopped there, he would have committed no crime, and we wouldn't be here today. But the defendant didn't stop there. Instead of going back to Ms. Hunterton, his therapist, and obtaining a more detailed letter outlining the conditions that Ms. Hunterton felt would allow him to see his children but ensure the safety of everyone. Instead, the defendant took matters into his own hands, and he took the letter that Ms. Hunterton wrote for him, and he added a sentence. I do not believe that Mr. McDonald is a danger to himself or to others. He took that into his own hands, he altered that letter, and then he filed it in his family court case on 3 separate occasions, committing multiple offenses. He filed it on December 4th of 2017, he filed it on March 13th of 2018, and he filed it on March 21st of 2018. When he filed it on March 13th of 2018, he filed it as part of an exhibit list. And in that exhibit list, there was also his general financial disclosure form, in which he claimed, thereby perjuring himself, that he was unemployed and had approximately $800 of income each month, when in reality, he had a salaried position as a systems administrator. And then a few days later, March 16th of 2018, he testifies at his family court hearing, the hearing for which that exhibit list was filed, and he perjures himself again. And he testifies again that he has no employment other than odd jobs, that his income is essentially $800 a month, when in reality, each of his paychecks is over $1,800. Now, in every criminal case, the state is required to prove 2 things. What crimes were committed, and that the defendant is the person who committed those crimes. In other words, what happened and who did it. And I'm actually going to address number 2 first, just who. And I'm not going to belabor the fact because, for lack of a better word, ladies and gentlemen, this isn't really a whodunit. This isn't something like a robbery where it's an identity case and someone needs to pick somebody out of the lineup. At this point, the evidence has shown that it's the defendant's conduct that brings us into court today. You heard testimony from Christina O'Connor, who works at the family court clerk's office. She testified that all of the pleadings in this case were filed at a customer service counter. The December 4th, 2017 pleading was filed in this building, in the district court clerk's office. And the pleadings filed on March 13th of 2018 and March 21st of 2018 were filed at the family court clerk's office. You heard testimony from Brett Sagaski, the marshal who works in this building, and he testified that he saw the defendant on the surveillance video from this building. And when? On December 4th of 2017. That's the date that the defendant first filed the forged letter in his family court case. You also heard testimony from another marshal, Timothy Spees. He testified that he saw the defendant, Michael McDonald, in the filing room of the family court center on March 13th of 2018. It's called the reading room, but as you heard him testify, that's where people go to file their family court documents. That's the same day that he filed his exhibit list. There's the date, and there's his name in the upper left corner. Now, you also heard some testimony from Detective Aaron Stanton about executing the search warrant at the defendant's home. And there was a lot of evidence recovered and photographed in the execution of that search warrant. And the defendant actually assisted Detective Stanton in finding a lot of this evidence. The defendant initially told Detective Stanton that there was probably a photograph of the letter that was on his phone, but it had been deleted, and said that it would be on his Google Drive. The defendant pulled this document up himself. And that's the altered letter on the left. I'm sorry, that's the altered letter on the right. That's the original letter on the left. There's the additional sentence. I do not believe Mr. McDonald is a danger to others or himself. So both versions of the letter are on the defendant's computer. The defendant is the person who pulled these items up. So at this point, there should really be no question, it's the defendant's conduct that we're concerned with today. And what else was found in the search warrant? A binder containing the letter. And that's a copy of one of the court pleadings, filed December 4th of 2017, found in the defendant's home. And inside of that was a copy of the forged letter. There's a copy of one of the pleadings that the defendant filed March 21st of 2018. again, containing a copy of the forged letter from this case. So the defendant is seen in the Regional Justice Center, this building, on December 4th of 2017. He's seen in the family court reading room where people file family court documents on March 13th of 2018. His name and signature is all over these documents, and all of the admitted documents and videos and everything that was admitted as exhibits you'll have with you to review for yourself when you're in your deliberations. There's the defendant's signature again, March 21st, 2018. There's his name. It's on the upper left corner of all of these documents that he filed. Further, the defendant admitted to Detective Stan that he filed the documents. He never said, wait, what are you talking about? I don't have a family court case. And he admitted it right away when Detective Stanton came to talk to him. We talked to him about his family court case, all of the issues that he was having. He wasn't in denial. On March 16th of 2018, you saw the video of that hearing in which the defendant testified. He stated that he filed the exhibit list, the one that was filed March 13th of 2018, that contained both the financial disclosure form as well as a copy of the forged letter. That's him being sworn in, March 16th of 2018. Now I want to bring your attention to one of your jury instructions, which tells you that you can use your common sense, your everyday common sense and judgment as reasonable people. You're not limited solely to testimony. You're permitted to draw reasonable inferences from the evidence based on your everyday common knowledge. Now I'm going to move on to talking about what crimes the defendant is charged with. And this is actually the order I'm going to talk about them in, which I apologize is kind of a different order from what's in your copy of the indictment and the jury instructions, but I think this will make the most sense to you when I explain the elements of these offenses. So the defendant is charged with three counts of forgery, 3 counts of offering a false instrument for filing a record, 3 counts of burglary, and 2 counts of perjury. So I want to address the forgery first. And as one of your jury instructions tells you, any person who falsely makes, alters, forges, or counterfeits any record or any document or paper recorded in or filed in any court with the intent to damage or defraud any person or persons is guilty of forgery. So you actually have 3 different forgery instructions in your packet because there are 3 different ways that the defendant committed forgery in this case. Okay, and that's why your indictment is so long, because it lists all of the different ways. Another way you can commit forgery: any person who passes or attempts to pass as true and genuine any false, altered, or forged record or any document or paper recorded or filed in any court, knowing it to be altered, forged, or counterfeited with the intent to prejudice, damage, or defraud any person is guilty of forgery. And finally, a person who, with intent to injure or defraud, makes any false entry in any public record or account is guilty of forgery. Now, I submit to you that the state has proven beyond a reasonable doubt that the defendant committed forgery under all 3 of these definitions. But in your deliberations, some of you might disagree. Some of you might feel that what he did was actually altering the letter. Or some of you might feel he did all 3. Some of you might believe that he only did the second version, which is passing off a forged letter as genuine to the court. And it's okay if you disagree, as long as if you all are unanimous and agree that he committed forgery, regardless of which version of forgery he committed, then you can find him guilty on that count. But I want to go through these and explain how he's actually guilty of all 3 versions. So there's the alteration of the document that he filed. When the defendant did that, he was committing forgery. When each time he filed a document and passed off that altered document as genuine, he was committing forgery. So on December 4th of 2017, March 13th of 2018, and March 21st of 2018, each time he was committing a forgery simply by going to the court and representing that this document was true and accurate, that this letter that Nancy Hunterton had her signature on was actually her letter. And by doing so, he made a false entry into the public record of his family court case. So December 4th of 2017, the defendant takes this document. It contains this forged letter. The red section is the forgery. And I want to emphasize this a little bit because there was some insinuation in the questioning throughout this case that this document isn't really forged because maybe the sentence itself is somewhat accurate. But the falsity of this letter is that the defendant is representing it as the letter that Nancy Hunterton wrote. It's not. She didn't write this letter. The one she wrote did not have the sentence in it that's underlined in red. So by representing that this letter is what Nancy Hunterton said, the defendant was committing forgery. He was passing off this altered document as genuine when it is not. And you heard testimony from Ms. Hunterton that even if she had written another letter, it wouldn't have exactly said this in the first place. But regardless, these are not Nancy Hunterton's words. Okay, this is not the letter that she wrote. It's an altered and forged version of it. The defendant passed this off as the letter written by his therapist when it was not. Okay, that's the deceit, that's the forgery. This is the letter that Nancy Hunterton wrote that doesn't have that sentence in it. So this is the genuine letter. This is the false letter. And so the defendant committed this crime, as I said, on 3 occasions: December 4th, 2017, March 13th of 2018, and March 21st of 2018. Each time that he passed off this altered letter as genuine, he was committing forgery. And the last requirement of forgery I want to talk about is intent to defraud. So defraud really just means to lie or deceive. And what was the deception here? He was passing off this letter as something that Nancy Hunterton wrote. She didn't write it. She wrote a letter. As soon as the defendant added that additional sentence that she didn't write, it became a forged letter. It was altered. It was no longer true. What he submitted to the court was a complete forgery. Now, offering false instrument for filing a record, this is a somewhat simpler crime compared to forgery. There's no intent to defraud here. The definition here is any person who knowingly procures or offers any false or forged instrument to be filed, registered, or recorded in any public office, which instrument, if genuine, might be filed, registered, or recorded in a public office under any laws of this state or the United States, is guilty of offering a false statement for filing a record. And that's really just a ridiculously long way of saying whenever you file something in a court or other type of recording office that's false and you know it's false, you're committing this crime. And similar to the forgery, he committed this crime on 3 different occasions: December 4th, March 13th, and March 21st. Every time he filed that forged letter, he was committing this crime of offering false instrument for filing a record. This letter right here. Now, I want to talk about the burglary now. And I know some of the more curious among you have probably been wondering why he's charged with burglary. Because I know kind of the common layperson way we talk about burglary is typically when somebody breaks into your house, they're committing burglary. But in Nevada, that's actually not the only way you can commit a burglary. The actual legal definition of burglary in Nevada is any person who by day or night enters any room or building with the intent to commit any felony is guilty of burglary. So the key is just entry into the room or the building with the intent to commit a felony inside that room or building. So entry and intent. So I'll talk about each one of those. So in this case, the defendant is charged with 3 counts of burglary. So that's why there was so much testimony about where these documents were filed. So every time the defendant entered either the room in this building to file his forged documents or entered the family court building to file his documents, he was committing burglary. Do we know that he entered those places? Well, December 4th of 2017, Brett Sagaski saw the defendant on surveillance video inside of this building, the Regional Justice Center, located at 200 Lewis Avenue. That's the day that this document was filed. And you heard Christina O'Connor's testimony that this document, the December 4th, 2017 pleading, was filed at the customer service desk at the district court clerk's office, which is in this building. And Detective Stanton testified specifically that that's room 3317 on this building. in this building. So there's plenty of evidence here that beyond a reasonable doubt, the defendant came into this building, the Regional Justice Center, and entered room 3317 in order to file this document which contained a forged letter. March 13th, similarly, on that date, this document was filed in family court. This document contained the forged letter and the financial disclosure form. Christina O'Connor testified that this document was filed at the Family Court Center, which is located at 601 North Pecos Road, and it was filed on March 13th of 2018. Timothy Spies saw the defendant in the reading room at the family court on that date, the same room where people go to file their family court documents. Now, March 21st of 2018 is the last burglary count. That's the date this document was filed in family court. And Christina O'Connor testified that this motion was filed on March 21st, 2018, in person at the Customer Service Center at the Family Courts and Service Center at 601 North Pecos Road. Now, the second part of burglary is intent. Because some of you may be thinking, well, how do I know what his intent was right at the moment that he entered the room or entered the building? You know, I'm not a mind reader. But you don't actually have to be a mind reader. As one of your jury instructions tells you, the intent with which someone does something can be inferred from the defendant's conduct and from the other circumstances surrounding the case. In other words, what a person does can tell you something about what that person intended to do. Okay, so on December 4th of 2017, when the defendant entered the district court clerk's office in the Regional Justice Center, this building, what did he do? Well, he filed a forged document. He offered a false filing to the court. Okay, that's why I went through those offenses before I got to the burglary. So we can tell what his intent was because that's what he did upon entering those buildings. It's not like he worked there and had some other reason to be there. That's the purpose of the district court or clerk's office, is to file your documents there. Okay, so you don't need to be a mind reader. What did he do in room 3317? He filed these forged documents. So when he entered, he had the intent to commit the crimes of offering false instrument for filing a record, as well as to commit forgery. And in order to commit this crime, to have the required intent, you don't have to be thinking to yourself, oh, I'm going to commit forgery right now, or oh, I'm going to commit offering false instrument. No, you don't have to necessarily know exactly what crime you're violating. You just have to have the intent to commit the act. When the defendant, Mr. McDonald, entered those rooms, he knew he was filing a document that had been altered, a document that was forged. He knew what he was doing. He may not have known the name of the crimes, but he was acting knowingly. Now, perjury. There are two different counts of perjury that are charged in this case. So that's counts 6 and 8 of the indictment in this case. So I'm going to talk about count 6 first. Now, to commit this crime, in a declaration made under penalty of perjury, making a willful and false statement in a matter material to the issue or point in question. I know it says 2 elements, but sorry, that's a typo. There are actually 3. So first, in a declaration made under penalty of perjury, you make a willful and false statement in a matter that's material to the issue or point in question. So I'll go through all 3 elements. Now, the first one is the declaration. And so what I'm talking about here is the financial disclosure form. And this may be a little different from what you think of typically when you think of perjury, but it's not just testifying in open court. It can also be when you sign a document. And this is a snippet from Exhibit 5, which contains the financial disclosure form that the defendant signed. And on this form it states, I swear or affirm under penalty of perjury that I have read and followed all instructions in completing this financial disclosure form. I understand that by my signature, I guarantee the truthfulness of the information on this form. I also understand that if I knowingly make false statements, I may be subject to punishment, including contempt of court. You have signature, and what's the date? March 13th of 2018. And you heard some evidence that the defendant, Mr. McDonald, may have filled out a financial disclosure form back in September, back before he was employed by Logistics. But what is the date on this form? March 13th of 2018. On this date, by signing this, he was telling the court what's contained in this document is true. I'm swearing that under the penalty of perjury. So we have the first element met. That's the declaration. And we know that it was false because this is from another exhibit, the Progistics employment records, which show the defendant was hired on October 23rd of 2017. He had a salary of $47,500, and he was a full-time employee. He was a systems administrator. But this is what he put on his financial disclosure form. Gross monthly income, 0. My gross year-to-date pay is, honestly, I'm not really sure what that says up in the right corner. It kind of looks like a 0. I think when he testified, he said he added a question mark to it. But it doesn't look anything like what his actual salary was. It's a couple of zeros right there under annual salary. But what was his actual salary? $47,500. Do we have a willful and false statement? I don't know how it could be any clearer. He filled out a form stating that his annual income was 0, when in reality, at the same time, he had a salaried position as a systems administrator in which he's receiving $47,500 a year. There's his pay stub. So as I pointed out before, he signed that declaration under penalty of perjury on March 13th of 2018. What's the pay period on this pay stub? March 6th through March 27th of 2018. Looks like he's employed at me. That's his name in the upper right corner. You heard Lisa Smith's testimony. She's the VP of HR at Progistics. She said she saw Michael McDonald every workday. He was their IT guru. And how much is he getting paid? About $1,800 every pay period. It's a heck of a lot more than 0. Now, was it material to the proceeding that he was there for? Well, it was a child custody hearing. It was an evidentiary hearing related to that. And you heard Marshall Willick, and who's an expert in family law and has been practicing family law.
That's not evidence. I think material was testified to.
Overruled.
Now, what I mean by material is essentially that it was important, that it was related to something being decided at the hearing. If Michael McDonald had just, say, accidentally said he was born on October 21st of 1983 instead of October 22nd, we wouldn't be here. Not really material to a family court case, you know. But in this case, he lied about his financial status. And you heard Marshall Willick testify. He's been practicing family law for approximately 30 years. And he discussed the financial disclosure forms in particular. A person's financial status, I believe he used the word critical. He said that it was critical to making determinations regarding child custody, child support, spousal support, all kinds of family court issues. This wasn't some minor matter that he made misrepresentations about. This was something that was very critical to the proceedings, that Mr. McDonald, the defendant, was purposely and deliberately deceptive about. So that's count 6. And now we'll move on to count 8. So this is the more traditional version of perjury. So to commit this kind of perjury, it occurs when a person, having taken an oath or made an affirmation in a judicial proceeding where it's required, swears and affirms willfully and falsely in a matter material to the issue or point in question. So kind of similar to the witnesses in this case, they were all sworn in to tell the truth. And you saw Mr. McDonald swear under oath on the video. So again, these are the 3 elements: swearing under oath, giving willfully and falsely testifying in a matter that's material to the issue. So was Mr. McDonald under oath? Yes. You saw him get sworn in on a video on March 16th of 2018 in family court. There he is raising his hand. Was his testimony willfully false? Well, he testified that he was unemployed, other than having some odd jobs. And this wasn't some minor mistake. He didn't say that he only made $1,860 on one paycheck when it was really $1,808. What he actually said was that he was not employed, that all he had were odd jobs, and in reality, he had a full-time position as a systems administrator at Judicial District. He was working there since October 23rd of 2017, and was still working there on the date March 16th of 2018, which is when he testified. He testified that his average monthly income was $800. And at various points, it seemed like he was saying it was $800. At some points, he said it was $0. Sometimes he seemed to be hedging it, but he clearly didn't say it was anywhere near what it actually was. In reality, his annual salary was $47,500. And you've seen his pay stubs. Each one was more than $1,800, and they were 2-week pay periods. I don't know how it could be any clearer that the testimony the defendant provided on March 16th of 2018 was willfully false. And I've already discussed the fact that it was material to the issue. Similarly to the information that he put on his financial disclosure form, his testimony, his live in-person testimony, was also material to the point in question. And largely what he was testifying about, or at least what he was cross-examined about on that you saw in the video, was the information that he wrote down on his financial disclosure form. And he acknowledged during his testimony that that was his form, that that was the exhibit that he filed. Now, so what do we have here? The defendant obtained a letter from his therapist, Nancy Hunterton, about August 31st of 2017. He got that letter from Ms. Hunterton. He added a sentence to that letter to make it appear as though Nancy Hunterton had stated that Michael McDonald was not a danger to his children or to himself. But she did not write that. That's what makes that letter false. The defendant passed that letter off as genuine, as the actual letter that she wrote, when it was not. He did that on 3 occasions. He perjured himself, both by filling out his financial disclosure form, the declaration under penalty of perjury, and by giving false testimony on March 16th of 2018 when he testified in family court. I submit to you that the state has proven beyond a reasonable doubt that the defendant is guilty of all of the counts listed in the indictment in this case. 3 counts of offering false instrument for filing a record, 3 counts of forgery, 3 counts of burglary, and 2 counts of perjury. I ask that you find the defendant, Michael McDonald, guilty of all